Good morning. I'm Travis Copenhaver.
I'm Nicholas Galendez.
This is Cannabis Live. We're here today to talk about updates in Michigan's medical marijuana laws and go over different topics in detail to kind of get everybody up to speed on how marijuana is unfolding here in the state of Michigan. Today we're going to talk about a topic that comes up a lot in our day jobs, especially when we're going to different municipalities, talking about how the Medical Marijuana Act and the Medical Marijuana Facilities Licensing Act kind of works, what the expectations are for the different cities and townships, considering how they want to interact with these laws. And usually one of the first questions almost everybody has when they're not used to dealing with medical marijuana as well, I thought marijuana was federally illegal.
What about federal law? How
Exactly.
does that affect me? What can I do? What can't I do?
Exactly. So we're going to kind of give you just a quick overview of federal law and its impacts on Michigan's medical marijuana programs and its impact on what will soon be its adult use program. And this is really just kind of a primer intro. The challenge with this topic is that it's complicated. There's a solution, and it's obviously working because we have about 30 states that have medical or adult use marijuana right now. The vast majority of the population of the United States lives in a state where marijuana is legal for either medical or adult use purposes. But that doesn't make it easy to explain, how federal law and state level laws interact. Mm-hmm. So to start, it's usually important to understand why is marijuana federally illegal. It's federally illegal because of the Controlled Substances Act, and this might be review for a lot of you, but cannabis is still considered a Schedule I controlled substance, which means it has no, accepted medical use according to federal law. What does that kind of mean, Nick?
I think that it's kind of a chicken before the egg thing. There's a long history as to why marijuana is federally prohibited as well as for the state level. When something's prohibited from being researched, obviously there's going to be hard, difficulties in actually getting that medical research done to see if it does have an effect. So I think it's, without getting into the history and reasoning behind that federal prohibition, I think it just happens to be how things were and how things have been for a while. Right. And, as we're going on and learning more about it in different states and kind of the laboratories of democracy, things are kind of loosening up, it seems like, and trending in the right direction.
Right. So cannabis has been and continues to be illegal under federal law and it has been for over 100 years at this point. Feels like it anyway. So anyway, obviously that's been changing a lot in a lot of states, including in Michigan at the state level. But, it's important to, before we go into the details of Michigan's laws, think about, well, how do we have 30 states or 30 plus states that have some sort of legalized marijuana? And it's complicated. Like I said, the main reason is even though marijuana is federally illegal, that doesn't mean federal governments have the power to enforce that on the different states. We have this concept of what's called federalism, which means we have two bodies of power that govern citizens of the United States. We have the federal government, and then we have state governments. And beyond that, we have local governments as well. And the way our states have powers is by through the Constitution and the amendments, Bill of Rights, and all of that. And some of those powers, create different ways to create laws. The Controlled Substances Act is a Commerce Clause power. It is regulating the trafficking of substances between states. That is where the legal justification for that law comes from. When states are enforcing, drug laws, those are police power rights. It's coming from either our health powers as states or as our police powers as states. And because we have two different theories of law creating the enforcement of any drug, including marijuana, we have this situation where different laws allow or different powers allow these different governments to create things. Mm-hmm. And that's all a complicated way of saying just because marijuana is considered illegal under the Commerce Clause powers doesn't automatically require states to make it illegal and enforce those illegal penalties under their rights to police and govern their citizens.
Mm-hmm. And I think this was a big argument during the founding of the United States where, we wanted the federal government to have powers, but the states also wanted to retain a lot of their powers. So eventually that was kind of laid out in the 10th Amendment, which says that, in the Constitution, this is the law of the land. And if there aren't things in here restricting the states, then those decisions are left to the states or the peoples of that state.
Right.
And so it was kind of a compromise and an acknowledgement that we do want the states to have somewhat of a free reign in certain issues to govern on their own. And we've definitely seen that in a recent Supreme Court case dealing with gambling out of New Jersey that included marijuana language, or at least some supporting marijuana language for this argument. So that's just kind of seeing this principle in action.
In the broadest of strokes, this is what we call anti-commandeering. Effectively, the federal government cannot force state governments to enforce federal laws. So what this all kind of basically means in layman's terms is the federal government can create penalties for the possession and use of marijuana, but they cannot force states to enforce those rules, right? That's called commandeering. That's where the federal government can't say, state, you're not allowed to legalize marijuana. But that doesn't mean the federal government is powerless. They have significant power to do a lot of things to impact laws, and any law, including different states' medical marijuana laws and certainly adult use laws. And that's just the broadest of strokes. We'll try to illustrate that a little bit more as we explain, well, how does that impact the laws of a state, say the state of Michigan? But before we jump into Michigan details, there's one other major federal level situation you should be aware of, especially for medical marijuana. And you've probably heard this a million times. We'll try to explain it briefly. But there's an appropriations provision called the Rohrabacher Amendment. It was now called the Rohrabacher Amendment. Some people refer to it as the Joyce Amendment. What that is it is a spending prohibition on the Department of Justice. So if marijuana is federally illegal, the groups that would enforce and prosecute federal law would be the Department of Justice. The Department of Justice, can't operate if it doesn't have money to spend. It needs to have monies appropriated to it so that it can carry out its duties. The Rohrabacher Amendment it's just easier for me to say, but that appropriations provision was first put in place in 2014. It's been basically, updated or approved or, reinstated about 11 times. Just recently back in, I want to say May or March. Earlier this year, and it will probably be done again until we get more significant changes at the federal level.
And there's always a little bit of, nervousness and anxiety of if it's going to be,
And the reason for that is this. If a state is implementing a medical marijuana law, and if someone is operating under the scope of that state's law, which means they are legal under the state's laws, the Department of Justice has a spending budget of $0 to enforce federal law against that person. What that means is basically if you're doing what you're supposed to under state law and it's a medical marijuana law, the Department of Justice is not going to be able to spend its funds to prosecute you and enforce federal law. So what that doesn't mean is if you're in an adult use jurisdiction, that doesn't prevent them from doing that. Or if you're not legally compliant with your state's laws, they can enforce in that situation as well. So that's effectively, if you are doing what you're supposed to in the state of Michigan under either of these laws, you're not being accused of violating state law, the Department of Justice cannot come in and, say, punish you for violating federal law. They can say you're breaking the law, they just don't have any money to actually prosecute you. So that's kind of a big, broad overview of everything from the top down. We're going to talk about a few ways federal law kind of impacts the Michigan programs. There's two of them in effect right now, the Medical Marijuana Act for patients and caregivers, the Medical Marijuana Facilities Licensing Act for the 5 new businesses that are licensed. And then we'll be voting in November on an adult use law, and we're going to talk about how federal law works with all of that. So to start, though, one of the most frustrating things I think we have to deal with is when we're going before municipalities, they're talking about implementing these different medical marijuana laws, and local officials at any level are effectively always going to say, well, marijuana, there's a drug-free zone, Controlled Substances Act, marijuana is illegal. We don't have the right or the ability or the legal authority to do this because it's federally illegal, which 9 times out of 10 is just an excuse so that they can use because they don't want to do it. But let's talk about what the Controlled Substances Act actually says, and specifically we're going to talk about what a lot of people refer to as a drug-free zone or buffers from different sensitive uses like schools.
So this is typically referred to as a drug-free school zone federal law restriction, and it'll also, there contains a similar provision in Michigan law on this issue. To call it a drug-free school zone law, though, I think is a little bit of a misnomer. These two particular provisions in both federal and state law don't say municipalities in a state you can't have things 1,000 feet away from a school or a
Right.
park or a church.
What does it say?
Both of them more or less say, we acknowledge these are controlled substances and there are crimes for those. If you do this certain conduct or these certain activities within this certain area, within this certain distance from a certain land use, then the penalty is enhanced.
Right. So effectively, under federal law, possession of any amount of marijuana is a federal crime. There's penalties if you commit a crime. What the sections of the Controlled Substances Act specifically that say, if the conduct occurred within 1,000 feet of a school or 100 feet away from like a youth center or swimming pool or arcade, if you're in these certain geographic locations near sensitive uses, any violation of the act is a crime with penalties. But if you did that in those certain locations, the penalties are even more. Right.
And let's talk about those certain locations. So federal law, it says if you commit a crime involved with marijuana and you are 1,000 feet from a school or a playground or public housing, you are subject to enhanced penalties. Or if you are 100 feet away from a youth center, swimming pool, or video arcade. So under federal law, those are the handful of locations where if you're 1,000 or 100 feet away from, you're subject to enhanced penalties. It says nothing about where a land use might be located. It's just more focused on the individual.
Now, remember, if you're not a medical marijuana patient or a medical marijuana caregiver right now, and you're in possession of marijuana, you're also breaking state law. So there are penalties under state law for possession or consumption of marijuana if you don't have a medical marijuana defense or you're not a medical marijuana patient. And in Michigan's laws, we also have enhanced penalties if you're in possession or consumption of a controlled substance, including marijuana, in certain places. I think it's a little less strict than federal law. Do you have this?
Yeah. So this one under state law, it's only 1,000 feet from school or a library. So obviously, there's not a really overlap between the federal law and the state law, even though they both say, hey, if you have marijuana as an individual and you're in this location, you're subject to enhanced penalties. So that's all these two laws say. It's not a drug-free school zone law, even though it does say if you're within a school zone, 1,000-foot radius, there's an enhanced penalty.
Right. So at this point, I like to pause and remind everyone who's been able to stick with it, because like I said, it's complicated to explain, that under federal law, possession of any amount of marijuana is subject to federal penalty. It's a crime under federal law. It doesn't matter if you're a patient, a caregiver, in an adult use state, it doesn't matter. Possession of marijuana, because of the Controlled Substances Act, is a crime with penalties. So if you happen to be charged of that crime and you were near one of these locations, the penalties they're going to attempt to put upon you are going to be even more. So instead of having 1,000 days in jail, it might be 2,000 days in jail or something like that. But it's still, because they're considering every part of it a crime. So under federal law, it's no secret, yes, possession of marijuana is a crime under federal law, and it has and always has been. But when the first state legalized medical marijuana, and now when the 30th states legalized marijuana, federal laws have not changed. But because we live in this world where we have two types of government, the federal government is calling that conduct a crime. But our state is not in certain circumstances, right? So let's talk about our two medical marijuana laws from this perspective. The first is the Medical Marijuana Act. And the Medical Marijuana Act creates patients and caregivers, right? And to not go into detail, patients and caregivers have to be under certain possession limits and grow in certain places and basically do a bunch of things to make sure that they stay following the law, right? Mm-hmm. So how does federal law impact that?
Well, there's a important case law that came out after the MMA that said it isn't preempted by federal law. So basically, federal law doesn't it isn't directly on point such that the state wouldn't be allowed to carve out a certain portion of its criminal code and say while we still recognize in Michigan that this is a controlled substance, this is a crime, you have certain immunities for engaging in conduct in accordance with state law as a caregiver or as a patient.
Effectively, the Medical Marijuana Act is a state law, which means if you do what it says you're supposed to, you're not going to be charged with state crimes. If me, a non-patient, non-caregiver, was in possession of marijuana, I'd be committing a crime. But if Nick, a patient, if he was, was doing the same thing, he would not, because the state law we've created, the Medical Marijuana Act, says if you're in compliance with all the amounts and requirements that you're supposed to as a patient or a caregiver, you're immune from prosecution from a crime. So just like in our other example, if I'm not doing what I'm supposed to and I'm near a school, I might be charged with higher penalties than if I'm not doing what I'm supposed to and I'm in the middle of a field nowhere near anything. It's still a crime. It's just what types of penalties am I subjecting myself to? So under state law, the Medical Marijuana Act effectively says do what you're supposed to, have a qualifying condition, or be a caregiver to someone with a qualifying condition, and you're not going to be charged with state crimes. Now, can the federal law still, charge you with crimes? Sure, but if, according to the Rockefeller Amendment, you're doing what you're supposed to according to the state of Michigan, the Department of Justice is not going to have any funding to prosecute you under federal law. And that's why this becomes complicated. But it's really not. Basically, if you follow your state's laws, the federal government is not going to have a ability to prosecute you in a medical perspective. And that not only applies to the Medical Marijuana Act, but it also applies to the Medical Marijuana Facilities Licensing Act. If a business is doing what it's supposed to under its state's laws, the Department of Justice does not have any funds to prosecute that business. All right? So we talked about the Controlled Substances Act's elevated penalties in certain locations. And specifically for the Medical Marijuana Facilities Licensing Act, here's what happens in almost every community I've dealt with, at least the conversation at one point. Well, marijuana is federally illegal, and the Controlled Substances Act, or Michigan's version of it, says you can't be within 1,000 feet of a school. Is that true?
No.
And why?
It isn't. The MMFLA gives, knowing what state law does when we talked about those 1,000 feet school property, library properties, it doesn't say this needs to be away from a certain amount. Same thing with federal law. Those are enhanced penalties for being, engaging in conduct in those areas. What the MMA does, for example, is it says that inconsistent state laws, at least, do not apply. It says that caregivers or patients can engage in the medical use of marijuana in only 3 locations. It doesn't say in also 1,000 feet from a school or library.
So what's happening in these 2 laws is the state of Michigan created a Medical Marijuana Act. The state of Michigan created a Medical Marijuana Facilities Licensing Act. And part of this program the state of Michigan created was decisions delegated to local municipalities about how their role in this is going to play out. And specifically for the MMFLA, municipalities get to decide a lot of things. They have a lot of power. They get to decide how many businesses are they going to allow, what kinds of the 5 businesses are they going to allow, and where are they going to zone those businesses. It doesn't say they have to zone them in certain ways, such as 1,000 feet away from a school. But it does say they can zone them however they want to. So if you're a city or a municipality or a township and you want to have a rule that says we don't want these businesses 1,000 feet away from a school, you're allowed to do that. You're not forced to do that. And that's the distinction a lot of these local communities fail to make when they're putting these ordinances together. Because no one's saying it's a bad idea to have a buffer from a school. I think a lot of people support that. I support that in most cases. But municipalities are all laid out differently. Your uses as they're strewn about your community might be problematic if you have a state level down law. And part of the flexibility this law creates is local communities going to make the decisions that are best for those local communities. And what's frustrating is when they're not engaging in the intelligent conversation of what kind of decisions and buffer rules from schools and churches and parks make sense for my community. Now, it's easy to just say, I don't have to make that decision as an elected official because I think federal law says I'm not allowed to do it. But that's disingenuous because the state of Michigan is the power that, by and through the state constitution that allows municipalities to have any power at all. So municipalities get to make the decisions that our state has delegated to them.
And I think it's very telling that in the MMFLA, there aren't really any zoning restrictions or distance requirements, buffers for the proper zoning district. All it says is that municipalities have the power to zone and limit things within their jurisdiction. It says that, the only restriction is that growers have to be in industrial or agricultural zones or unzoned, right, and it meets the definition of certain things. So along with that, the state constitution and the Home Rule Cities Act, if it's a city, gives them authority to zone and have the best interests of the public health, safety, and welfare in that community in mind. So for them to say, we're prohibited by federal law from having a facility within 1,000 feet, that's not necessarily how it operates. That's only them talking about the enhanced penalties. It's
Right.
proper for them to say, hey, as municipal officials, with the power granted to us from the Constitution, from state law, with zoning for the public health, safety, and welfare, we want a 1,000-foot buffer, or we don't. I mean, I think too, just talking ahead, there are some examples of municipalities that have relaxed zoning restrictions or no zoning restrictions for certain facility types. So to say that provisioning centers by federal law are required to be 1,000 feet away because of this federal drug-free school zone, but then allow growers to be anywhere as long as they're in an industrial zone, it doesn't quite gel and match.
It makes you look like you have no idea what you're talking about, because under federal law, you're not allowed, technically, the conduct isn't allowed anywhere under federal law. But federal law doesn't get to do the regulation of a medical marijuana program because the state of Michigan has created one. The state of Michigan says communities like a city get to zone however they want to. There's a little bit of a restriction under the MMFLA, specifically for the business type grower, where growers need to, pursuant to the statute, be in an area that allows either industrial or agricultural use. Now, when they passed the Medical Marijuana Facilities Licensing Act, that section could have said all medical marijuana facilities must be a minimum distance away from a public school or a religious institution or a city hall, but it didn't. It left that decision to the cities and townships that get to zone these businesses. And no one's saying a city or township can't make that decision, but what they need to understand is that is 100% the community's decision to make. If you want to draft an ordinance, let's take the city of Detroit, for example, that makes basically 15 different types of uses you need to be 1,000 feet away from. Schools, churches, parks, liquor stores, arcades. I think they got removed.
They got rid of arcades.
Yeah. So,
which is in federal law as
right.
well. So if it was required, they wouldn't
libraries,
remove it.
Right? Yeah. But they could have also added football stadiums, residential houses,
any land use.
Anyone with purple paint on their wall. I mean, it doesn't matter. It needs to be rational. But the basis of why they chose to make that is because, according to a city like the city of Detroit, those are uses they want to keep these types of businesses away from. They're allowed to make that decision. What's frustrating is when they think that decision is forced upon them because they misunderstand the law. So,
and I think just getting the semantics correct is really big here when you want the justification for why you're doing something to match with why it's actually being done. And It's not to say that, maybe what's really going on here, and obviously we're not privy to a lot of these meetings that, cities and townships might have with their legal aid, legal attorneys. But it might be that they don't want to subject the facilities to enhanced penalties in the case of facilities,
sure.
Slipping up, compliance is going to be big, following all of the regulations. And, if you slip up, there's a potential that if you're in this area that you'd be subject to enhanced penalty. So maybe that's what they mean by there's this federal law that we're doing, but it's just hard to get, make sure that they're saying it the right way. And
to me, it really comes across as I don't want to be, as my capacity as an elected official, the one responsible for the decision. I'm going to punt that to what I understand is a federal law. But it's really the community, whether it's a board of trustees or a city council or through a planning commission. It's whoever's drafting and designing the ordinance for the MMFLA and soon for the the adult use version of it if we pass that law in November. That decision is 100% the community's to make. You can be inspired by your concerns over federal law and enhanced penalties, or just it might be a good idea to have these types of businesses away from school. No one's saying it's not. But you have to own that decision because it is 100% the municipalities to make. That's how the law has been set up. And if you are in public hearings and saying, well, our hands are tied, federal law says we have to do this, you're wrong. Do a little more research. It's very clear. Federal law doesn't want states to legalize marijuana at all, but they have no right to stop states from doing that. States can do this. Now, federal laws could change where federal regulations, are designed in a way that preempts different state programs, but they failed to do so. Just like they failed to change the Controlled Substances Act, they've failed to design a set of regulations. What's very clear is our federal setup, the 10th Amendment, the federal law. States are allowed to not follow the direction of federal law. They're allowed to legalize marijuana, but that doesn't mean they're necessarily allowed to regulate the way those changes are going to be. But if federal law fails to create its own regulations and step in for and preempt the design of a state's program, then we have a situation where yes, marijuana is federally illegal because of these types of laws, basically Commerce Clause powers. And yes, states are allowed to say we're not going to create penalties for marijuana, effectively at the state level legalizing marijuana, whether it's for medical or adult use. And when most states do that, they're going to create a set of rules or regulations for how people can engage with marijuana, whether from a medical perspective or from an adult use perspective. And under state law, there might be penalties for stepping out of line there. Mm-hmm. And it gets complicated because we also have at the federal level limitations on the prosecution of federal law, and specifically for medical marijuana, if the operator at issue is following its state laws. That's what the Rohrabacher Amendment does. That's what these anti-commandeering principles do. It limits the scope of what our federal government can do. So yes, no one's saying marijuana isn't federally illegal, but we live in a world where the enforcement of most criminal penalties are done by and through the state and its local jurisdictions. And in the state of Michigan, if you're doing what you're supposed to, you're not committing a state crime. And I think more than 90% of all criminal charges are through state laws. So anyway, I got off on a bit of a tangent.
So you did mention, obviously, states are free to legalize recreational marijuana, at least from the state level. Obviously, it's going to take some, from our U.S. Congress to change it, the federal landscape, which I think we're definitely lagging behind, and it's kind of a topic for another show. But Marijuana Business Daily just released an international marijuana report on several countries to look at. And it's pretty baffling how many states in Europe and Asia and South America are legalizing recreational cannabis, and how behind I think the United States is going to be. This isn't a new gesture, but it's definitely going to be something to think about. We're so focused on Michigan, where if you look at recreational states and then just zoom out more and see the whole world, we're lagging behind because of our federal law. So that's just a little bit of my soapbox. But you mentioned about that. I think we should talk about how potentially, more cities are going to be opting in on the medical regime. We have the adult use ballot initiative coming up in November. Potentially talk about, are there any restrictions in there?
Let's look at the adult use ballot real quick, because, one of the benefits the ballot language has is it had a chance to look at the Medical Marijuana Facilities Licensing Act and, maybe take a few lessons. Now, when this ballot was being put together, the MMFA is still very new. But one of those lessons was being a little more clear to municipalities, right?
Very more clear, especially the kind of evolution we've seen from the MMMA. Can municipalities control caregiver conduct? What we've seen in DeRuyter is no, they can't. MMFLA gives municipalities the power to opt in. It gives them a little bit more say. But with the adult use ballot initiative, it kind of goes even more a step further. It says that there's those similar immunities for the licensable conduct, but municipalities are allowed to opt in or opt out. They can't adopt ordinances that are unreasonably impractical, and I guess we can talk about that in a little bit.
Sure.
It can't conflict with state laws or any rules, and it allows them specifically to do time, place, and manner regulations. So that we're kind of spelling out a little bit more language in the actual law as far as what can happen.
But specifically for buffers, which is where this usually comes up in the most frustrating way, it has language that is, not really that different from what the MMFLA has, but it's designed in a way to be very, very clear to the communities that are going to have to pass the types of ordinances the adult use ballot contemplates. And the language effectively says what?
It says that a facility can't be located in a residentially zoned area, like exclusively residentially zoned, or within 1,000 feet of a pre-existing K through 12 school. Unless a municipality adopts an ordinance that reduces this distance requirement.
Which means to me is exactly what the MMFLA says.
What it doesn't say, but doesn't, I think, need to say. But
right.
I think that it's really nice that this spells it out for municipalities, at least if this ballot initiative passes in November, what they can and can't do. And what they, this federal law and the state law that we just talked about and the enhanced penalties, how that might not actually impact them. Because as a refresher, the state law for these drug-free school zones says cannot be 1,000 feet from school property or a library, or if you're in there, you get those enhanced penalties. But what the adult use ballot initiative says is that the municipalities, maybe 1,000 feet away from the school, or they can restrict it to however they want to.
Right. So basically what it says is instead of just like giving municipalities free reign to design whatever they want, kind of like the MMFLA says. It gives them a default starting point. Okay, if you're silent, you can't be within 1,000 feet away from the school. But if in your community it makes sense for that to be a different number, let's say 500 feet away, because there's a big, area of Main Street that's a little too close to a school, but it's the perfect spot for these types of businesses. In our community, we're going to make the buffer 500 feet, or we're going to think that's not a problem because we're not allowing retail stores, we're only allowing growers and processors, right? So a municipality, just like in the MMFLA, under the adult use ballot, gets to design the zoning restrictions for these businesses however they want to. But unlike the MMFLA, where they can just do whatever they want and it doesn't give you an idea of what you should do, the adult use ballot has language that says, if you have no idea what you should do, here's some default rules. You can't be in a residential zone. You have to be 1,000 feet away from the school. But feel free to change that if you want, because you have zoning power. That's what you do as a municipality. So hopefully that will clear up some confusion for municipalities as they're deciding what they want to do under the adult use rules. But
yeah, and I think it's probably a misunderstanding, and these laws are changing and evolving. It's easy to see how you could read this and say, 1,000 feet from school or library. Well, I guess these facilities need to also be away from those, but that's just not how these particular areas of the law operate. Right. It'd be easy for it to say, if it truly needed to be followed as even, applicable to facilities, then in the MMFLA and the new adult use ballot initiative, it would have to say no facilities may be located within 1,000 feet of a school or library. And that would make sense. If it was spelled out 100% applicable to what the law was actually doing, then that would be justifiable. But it just, the way things are misinterpreted and kind of twisted and have, a spin put on it a little bit in certain situations is kind of fuels the confusion and then other municipalities will hear, that 1,000-foot drug-free school zone, we got to put that in ours too. Okay, great, those are the zoning restrictions. But what we're trying to communicate is that that's not exactly how it works, and there's definitely wiggle room to have those those prohibitions, but it's not an absolute requirement.
Right, and that's really the best conclusion we can make, and we'll basically end on this. Municipalities right now under the MMFLA can design whatever zoning restrictions they want. And no one's saying it's a bad idea to have a buffer of 1,000 feet away from the school. But what you should know if you're a community and you're designing that restriction is you're making that decision. The state of Michigan is enforcing you to do it. Federal law has no ability to force you to do it. You're making a zoning use restriction that makes sense for your community. And you're the one who made that decision. You don't get to hide behind the incorrect assumption that you have to do it. So if it makes sense in your community, no one's probably going to disagree with you. In most cases, I think that's a good use restriction. I think there's room for flexibility, but you're the set of government officials that get to decide that. And it's your decision to make. And it's your decision to not only explain to your constituents, but justify when people call you on it. Mm-hmm. So,
and also just, if you're interested individual in your community, either the medical side and a community that hasn't opted in, that's drafting an ordinance, in those communities that if the adult use ballot initiative passes, we'll have to go over it again, decide whether to opt in or opt out. These are important things to be telling your municipal officials and, clarifying it to them and making them understand too, because a lot of the time as well, as more and more municipalities get exposed to the licensing process and their own local application processes, they'll understand that it's a difficult thing to kind of, get a firm grasp on, because there's definitely a lot of moving parts. So I think the more information and the more educational that you can be as an interested party, just regardless of your status and what you're looking to do, I think that benefits everyone.
So we did focus there on zoning for a bit, but let's just, because we're getting to the end of our time today, but let's really briefly talk about a few other ways, this assumption that marijuana is federally illegal kind of impacts decision making. There's usually a big concern from communities that haven't had to deal with marijuana yet that there's some sort of liability on them if they pass these types of ordinances or they create rules and regulations about the businesses in their community. Effectively, the people violating federal law are the ones cultivating or selling marijuana. A state like Michigan has designed a program, and that program requires municipalities to pass ordinances. But at the end of the day, if federal law is going to be, enforced, it's going to be enforced upon the operator. Now, that operator needs to file applications and make disclosures and have their facility inspected. And if at some point that operator is not in compliance with state law, then there might be the risk of a federal penalty or a federal prosecution, but because the operators stopped following state law. That's when we shift out of medical marijuana's protections under the Rohrabacher-Bluehair Amendment, Rockefeller Amendment, that appropriations provision, and the Department of Justice now can, use funds to prosecute because the operators stopped following state law. It's the being compliant with state law that protects the business, or under the Medical Marijuana Act, if you're a patient and you're doing what you're supposed to as a patient, you're following the Medical Marijuana Act, you're protected by that appropriations provision, same as a caregiver.
And as far as violations as well, I don't think it's there's going to be a lot of compliance and regulations to follow. I don't think it's maybe a mistaken error by an employee in entering one, maybe he added a 0.6 instead of a 0.7, right? That'll be reconciled. While you will be subject to potential fines by the department, depending on how severe that is, I don't think we're talking about minor regulatory mishaps. We're talking about gaming the system, finding loopholes and seeing if they're going to work. And, there's some evidence from other operators in other states that got their licenses revoked or criminal prosecutions from federal law because of that. But we're definitely not talking about the very ground level types of
right. And if you're a local government and you're passing an ordinance, you're doing so in accordance with the Medical Marijuana Facilities Licensing Act. You're doing so in accordance with the state's law. If you're an official that's doing your job, pursuant to an ordinance or a statute designed by the Michigan Medical Marijuana Act or Medical Marijuana Facility Licensing Act, you're doing what you're supposed to. So you're not a target of federal enforcement, and in fact, you're really not even violating federal law because you're not growing or selling marijuana. The operator is, and that comes up a lot. But at the end of the day, we can also just be aware of the reality right now. Medical marijuana pulls in the 90+% of approval ratings now. We might argue about is the actual design of different medical marijuana programs popular or not, but the concept of medical marijuana polls almost at universal acceptance. We're in the 90%. Has federal law changed? Not yet. Will it change? Probably, but it's probably not going to be as fast as anyone wants. So, we're in a world right now where we have these dual laws, federally illegal, state legal, specifically for medical marijuana. And we also have, 10 jurisdictions right now that have adult use laws. Michigan might be the 11th. And, we can look to the states that have been doing this for several years and ask ourselves, has the federal government come in and shut down the city of Denver or the city of LA or the city, any community that has been doing what it's been doing, whether it's medical or adult use? And the answer is no. It's the operators that don't follow those laws that are targets, not the ones who are doing what they're supposed to. And, we're only going to see these laws change and evolve. We have movement at the federal level, bipartisan support of different statutes and changes trying to take medical marijuana, take marijuana out of the Schedule I, trying to give a room for states to implement these laws a little better, trying to create access to banking, all the ways that the federal prohibition of marijuana by and through its status as a Controlled One substance makes the practical operation of these facilities legally difficult. But legally difficult doesn't mean prohibited. And that's kind of the distinction a lot of people fail to make. Yeah. So I think we talked enough about federal law. And like I said at the top, from my perspective, to sum up, federal law is not a concern of mine when I'm working with clients trying to put marijuana programs together in Michigan, or marijuana businesses together in Michigan. Mm-hmm. If the reality is, if one of those businesses does something they're not supposed to, they're going to have problems with state crime, state issues. If you break Michigan's laws, you're going to be prosecuted by the state of Michigan. The federal government really isn't in the business and doesn't have the manpower to enforce federal law to those groups. Could they? Sure, but you don't see that happening. And
I think you have to be trying really hard to get the federal government involved, even with, that's just my own opinion and from reading things. But a lot of the things will be handled from the state law enforcement or even the state regulatory body at first. Right. You really have to be going out on a limb and to get the federal government involved with such a.
And nobody wants to break the law. I mean, if you're setting up a business designed to break the law, you're already going to have problems, right?
And I think that's the other thing too. Just to kind of on a tangent, those distance requirements concerns are valid, but need a little bit fleshing out. And hopefully we've done that a little bit today. But it's also a little bit the concerns about crime, robbery, odors. Those are all things that are being addressed at the very front end with vetting all of the applicants, with requiring such extensive narratives and operating plans, filtration systems, nuisance mitigations plans. Those are all valid concerns from an outsider, but once I think they get educated about all of the stuff that needs to go into these facilities, it's really a non-issue. And if it becomes an issue the second
there's
afterwards,
tools
it's going to be
something
remedied.
about it. Yeah.
So
Anyway, that's our lecture on federal law. Hopefully that cleared some things up or created more confusion, one of the two. But we're always willing to kind of try to explain it more to anyone who's interested in the topic. And unfortunately, it's complicated right now. But complicated doesn't mean problematic. It just means if I can't explain it in 2 sentences. So we coexist right now in the state of Michigan with the Controlled Substances Act and cannabis' Schedule 1 status. And there's efforts being made at all levels of government to change that. But the reality is there's nothing preventing the state of Michigan from doing the same thing most other medical marijuana states are doing, which is licensing businesses to operate and create safer and better access to medical marijuana for patients. There's nothing stopping patients and caregivers from doing private, 2008 MMMA grows if they're doing what they're supposed to. So, federal law is definitely something you shouldn't ignore. You should be aware of its risks, but you should also be aware of the reality of its impact on a program like this. So anyway, for Travis Copenhaver,
Nicholas Galendez,
thank you for joining us today, and we'll be back next week.
have a good weekend, everyone.